All rise.
The Kosovo Specialist Chambers is now in session.
Please be seated.
Good morning, everyone in and outside the courtroom. Mr. Court Officer, can you please call the case?
Good morning, Your Honor. This is the file number KSC-BC 2023-10, the Specialist Prosecutor versus Sabit Januzi and Januzi&Bahtijari. Thank you, Your Honor.
Thank you, Court Officer. And now I would kindly ask the parties and participants to introduce themselves, starting with the Specialist Prosecutor's Office. Madam Prosecutor.
Thank you, Your Honor, and good morning. The Specialist Prosecutor's Office is represented by Taz Shahabuddin, Prosecutor, Julie Mann, Case Manager, Maria Cristina Manolescu, Legal Intern, and myself, Silvia D'Ascoli, Prosecutor. Thank you.
Thank you, Madam Prosecutor. Now I turn to the defense. Mr. Rees, please.
Please, Your Honour, I appear on behalf of Sabit Januzi. Mr. Januzi is present. I'm assisted by co-counsel Mr. Hugh Bowden and team member Mr. Halilai.
Thank you, Mr. Rees. Mr. Sitema, please.
Thank you, Your Honour. My name is Hendrik Sietema, member of the Heartbreak, representing Mr. Bahtijari as duty counsel. Thank you.
Thank you, Mr. Sitema. And now I turn to the registry, please.
Before Your Honour does, I should say I'm terribly sorry to Mr. Bowden Jr. I'm also assisted by team member Mr. Daniel Bowden.
This is well noted, and this is now in the transcript. Thank you, Mr. Rees. Now I turn to the registry, please.
Good morning, Your Honour. Good morning, colleagues. Jonas Nilsson, Deputy Registrar for the registry today.
Thank you, Mr. Nilsson. And for the record, I am Nicolas Guillou, pretrial judge for this case. On 8 December, I scheduled the third status conference for this case. My goal today is to review the status of the case and to further organize exchanges between the parties to ensure an expeditious preparation for trial. In particular, I want to discuss disclosure, the status of the SPO's investigations, the points of agreement on matters of law and facts, the status of the defense investigations, issues related to the Specialist Prosecutor's joinder request, the anticipated transmission of the case file pursuant to Rule 72.1 and when the parties expect to be ready for trial, IT and facilities issues raised by the defense from Mr. Januzi, relevant to Mr. Januzi's preparation of his defense, and finally, any other issues that the parties may wish to raise. I thank the parties for their written submissions ahead of the status conference. And as usual, I invite the parties and the registry to present their views in a concise fashion about each item on the agenda, which I will address individually. I remind the parties and the registry to give prior notice should any submission require the disclosure of confidential information, so we can move into private session. Let's move to the first item in our agenda, which is disclosure. I would like to hear from the SPO on the progress made in the disclosure of evidentiary material. I have taken note of the SPO's submissions on the issue of disclosure. I note in particular that the SPO indicated that it will complete its Rule 1021B disclosure obligations by 15 December 2023. The SPO specified that Rule 1021B disclosure is being prepared in line with request F00108 and that it will seek authorization in court to proceed accordingly, pending a decision on the request. I note that a decision F00131, in which I granted request F00108, was issued yesterday. As a result, the SPO may proceed with Rule 102.1b disclosure in accordance with said decision. Madam Prosecutor, do you want to add anything to your written submissions on the issue of disclosure? And please note that the submission on the request for joinder will be dealt with later in the status conference today. Madam Prosecutor.
Thank you, Your Honor. That's duly noted. We took note of your decision, so we will proceed accordingly. No problem with that. Maybe I don't have anything additional to what was in our submissions, which Your Honors summed up. Maybe I can just reply to a couple of issues raised by the Januzi defense for purposes of completeness. So we noted that the Januzi defense indicated that they had encountered difficulties with the electronic files provided on 6 December. That's paragraph 2 of their submission. We discussed the matter briefly before court. It should be possible, to our understanding, to access the content using the native application that has also been provided. But of course, we are happy to assist further if that's not the case or if it doesn't work. So I just wanted to confirm that. Also, I wanted to add that a number of the requests that were brought forward by the Januzi defense, and I refer to paragraphs 3, 7, 2, and 12 of their filing, will be indeed part of the Rule 102.1b package to be disclosed this Friday. I'm happy to add anything else as a matter of clarification. Thank you.
Thank you, Madam Prosecutor. I will now give the floor to the defense to discuss any difficulties with the disclosure process, starting with the defense for Mr. Januzi. Mr. Rees, please.
Your Honour has our submissions for today's status conference, which we do set out a number of issues in relation to disclosure that presently arise. I won't take Your Honour through those line by line, as I know Your Honour will have read them, but there are aspects of them that I wish to address, and in particular, I'd ask Your Honour to consider making appropriate directions to the prosecution to respond to them. I know that there is a framework for disclosure in place, but it does seem to us that the more expeditiously that disclosure matters are raised and dealt with, the better. The framework for disclosure that Your Honour has set, of course, sets out minimum limits for meeting disclosure obligations. It doesn't prevent matters moving more swiftly. So we trust that requests for disclosure that we've made at this stage are treated in the spirit in which they're meant, which is to ensure that all parties move as quickly to a position where we can deal with trial readiness as soon as possible. In relation to the hard drive that was disclosed under Rule 101.2.1b, containing 3 forensic images of 3 phones, I am told that there should be software embedded on the hard drive that will assist the defence in viewing the material. Other members of my team have attempted to look at it. We haven't been able to. We were warned, in fact, when the hard drive was handed over, that the investigator who did that thought that we wouldn't be able to access the material without expert assistance. But in light of the information I've been told today, I will personally go myself and look to see whether I can find any executable program to assist us in viewing it. If I have difficulties with that, I will raise it with Ms. Dascali, and I hope that we will be able to resolve that one way or another. There are, though, a number of matters that we have raised in disclosure. Your Honour has a summary of them at paragraph 4 of our submissions. That relates to the request for call data records for a witness. Your Honour will recall that I raised that matter at the very first time I appeared before Your Honour in this matter, the second status conference, and Your Honour invited the prosecution to take appropriate steps to secure that evidence. No step has been taken thus far, and I would ask Your Honour to repeat in even more forceful terms the request that Your Honour made at the second status conference to the prosecution. That material should be obtained. It is specified by reference to a request for cold data in relation to other individuals, so there can be no complaint that our request lacks specificity. That matter should be attended to urgently. The status as to disclosure otherwise, I accept, is a matter that can wait until, firstly, the SPO have obtained the material and then reviewed it themselves. And of course, that was the position Your Honour took at the second status conference, raising that you weren't determining the issue of disclosure of it to the defence at that stage. But in the first instance, it should be obtained and secured. So I do ask for a repeat direction in relation to that matter. Then at paragraph 5 of our written submissions, there is a summary of other requests that were made, in fact, on the 5th of November in the form of inter partes correspondence. There is a list there of items 5A through to G. Now, I am conscious that in light of Your Honour's ruling yesterday, we will get some of that material, I anticipate, tomorrow as part of the further Rule 1021B disclosure. But there are still other requests that are contained therein that we haven't had direct responses to, despite being told, I think, on the 6th of November, that we would be receiving a full response in relation to those requests as soon as possible. At paragraph 7, there are requests. Paragraph 7, Roman numeral 2, I can foresee that that should be attended to, and in fact, effectively has been in light of Your Honour's ruling yesterday. But there is still a request at 7, Roman numeral 1. I don't understand, we haven't had a reason as to why there should be a delay in providing confirmation of the very straightforward matter that we saw confirmation of and is repeated therein. At paragraph 9, we refer to two outstanding matters of litigation that Your Honour is already seized with relating to disclosure. I'm conscious that in relation to one of those matters, the defence has a target to reply to the response of tomorrow. We will do that, but we await Your Honour's rulings and whatever consequential effect follows thereafter. I will leave the issues that are linked with the proposed disclosure joinder application that relate to disclosure until a later stage in this hearing. But the overall effect is, firstly, I'd ask Your Honour to assist with the direction for a full written response to each of the requests that we've raised thus far in the inter partes correspondence. And secondly, the acknowledgement with that, at this stage at least, as far as the defence are concerned, there hasn't been much progress by way of disclosure since the last status conference. There is, we are told, to be substantial disclosure to take place tomorrow. Exactly what that entails and the volume of it, the nature of it and so on, we have to wait until we've received it. But the effect is, at this stage, we find it very difficult to give Your Honour any assistance as to the issue about disclosure, the progress of it, and so on. We say it's premature. Unless I can assist any further.
Thank you, Mr. Rees. Mr. Sitema, please.
Thank you, Your Honour. Yeah, I guess I have to refer to my ex parte submission of earlier this week, in which I indicated that my contribution to this discussion would be very limited due to my position at this moment. I hope you understand that. In the meanwhile, I keep track of the good work the extending defense team of Mr. Januzi is doing, following their steps, and when necessary, I will follow them. But as to my contribution to the discussion, as said, it will be very limited, also for the coming matters you address today. Thank you.
Thank you, Mr. Sittema. On the point you just mentioned, I don't see any reason why your contribution should be limited. You are a duty counsel. You should assume the full functions of your office. There is no limited contribution in the framework for assistance of counsel. So I hear your position, but vis-à-vis this court, you are the lawyer of Mr. Bahtijari, and you should assume the totality of the functions until further decision. So there is no defense that is not fully effective, and I think this needs to be clarified if it was not enough clear in our legal framework. Before I give the floor to the registry, let me ask to the prosecution, let me ask the registry, in case the defense of Mr. Januzi has any difficulties to use the mysterious software with the hard drive. I have no idea how this works. Is the registry able to assist in providing IT advice to the defense team?
The registry will always be able to assist, or will try to assist as well as we can. We don't know, of course, more about the software and what the problem is, but we will aim to assist if it is the course.
Thank you, Mr. Nielsen. This means that in case Mr. Rees is not able to access information himself, despite his IT skills, and if the discussion with the SPO is not sufficient to provide further guidance, I invite the parties to consult with the registry so an IT specialist can assist in explaining how this software works in order for the situation to be resolved. Now I give the floor to the prosecution to reply to the defense teams, please.
Yes, thank you, Your Honors. Okay, I will start with the defense request regarding our replies to an inter parte correspondence, the one dated 5 November. I think it should be obvious to the defense from the content of our filing the request for protective measure of Rule 102.1b material, F0008, why certain part of that email could not be answered to before yesterday. And I think it is obvious also in light of Your Honor's decision F00131 that a substantial part of those requests will be, in fact, met tomorrow. There are two other issues related to the inter partes communication. We also communicated via email on the 13th of December that, in fact, we do not possess any audio-video recorded copies of the recording specified in the defense request, and that everything that we possess, that is the official notes that the defense is aware of, will in fact be provided, those that are not available yet tomorrow. Additionally, with regard to the call data records for witness 1, this has also been dealt with by way of an inter partes communication. The SPO has informed the defense that it is considering indeed the request, that also is not under any obligation to carry out investigation on behalf of the defense. However, having received the reasons, we are considering the request. This is for what concerns the call data records. However, as Your Honours is aware, we did take steps to secure witness 1 mobile, and further details about that are also containing Annex to F00126, that is the SPO submissions to this status conference. So that should give a fuller picture to the defense queries. There was also a point in the request, this is paragraph 5 again, asking for copies of audio recording of the witness interviews that we will be disclosing by way of transcript tomorrow. It is neither legally required nor it is the SPO practice to disclose the audio videos of the transcribed interviews. And it's for a number of reasons, including practical arrangements such as the labor-intensive process of applying any redactions to the videos. The defense will receive the transcript of the interviews that they refer to in paragraph 5A and B of their submissions by the deadline. There is tomorrow, the 15th of December. Considering the scope of their request and the limited reductions, if any, to be transposed onto the videos of those same interviews, the SPO is willing to make an exception to its practice and indeed provide the videos of those transcripts. However, that cannot be done by tomorrow, and it will be arranged as soon as possible, we believe, January 2024. Regarding the defense request in paragraph 5G and 7, there's been a number of Rule 103 material provided on 16 November. Additionally, with regard to the defense request for confirmation that Mr. Januzi has no criminal record, the SPO is not in a position to confirm that, but he has now processed a report that we procured about that. And while this will be part of the Rule 102.3 package, of course, we are willing to disclose it earlier to the defense. We do not see any issue with that. Therefore, in advance of the Rule 102.3 disclosure deadlines. I think that concludes my additional remarks. Thank you.
Thank you, Madam Prosecutor. Before I give the floor to the defense, I would like some certainty about the CDR. Can you confirm today that the preservation of evidence and the evidence requested by the defense regarding the CDR is being requested by your office, which means that the defense do not need to make a specific request in that regard? I say that because if you are not entirely sure, I will invite the defense to make a formal request before me so that this can be dealt with before we have any risk of disappearance of evidence, especially in this specific matter. That's the reason of my question, Madam Prosecutor.
Your Honor, yes, as I said, we are considering that request. We are inclined to do it, but I cannot give a final answer today. But of course, the defense has been informed by Your Honors of otherwise the procedural step. We will reply if it is not by tomorrow, by early next week, but we don't see reasons to further delay the final answer, which, however, I cannot give right now.
So, Madam Prosecutor, I understand from your submissions that it's not yet a commitment, but that a firm answer will be given to the defense by tomorrow. So, would your office decide not to proceed with the CDR and the material requested by the defense, I invite the defense to make a formal request before me so I can rule on this matter. That's clear for the parties?
That's clear, and I appreciate it.
That's clear. Thank you, Your Honor.
Thank you very much. And of course, I invite the prosecutor to to avoid unnecessary litigation. Now I will give the floor to the defense to respond to the prosecutor's submissions. Mr. Rees, please.
Yes, I'm grateful for the clarification received from Ms. Dascoli as to some of those matters. In particular, the fact that steps have been taken in relation to the seizure of a phone, one of the matters that we raised at the second status conference. Can I raise this as again, in a spirit of cooperation, to allow matters to progress? Obviously, we understand that there are occasions where the prosecution will seek ex parte orders before the court. It's never seemed to us, however, that means that there can't, for example, be communication when a matter is raised in inter partes correspondence, just to let us know that matters are in hand and that the prosecution are seeking an ex parte order from the court without going into necessarily the content of the order or any of the detail. That would be of assistance to us to know that matters are being attended to rather than being left completely in the dark until as and when any such order is reclassified, if an order is made. It would be of assistance, and we obviously do understand that the prosecution, there are times when the detail they can't divulge, but communication of that nature would be of assistance. We will wait to see what the response of the SPO is to the matter that Your Honour has just dealt with, and I'm grateful for Your Honour's direction in that regard. I think the other matters that are raised effectively, our position is we need to wait until we've received further disclosure before we can assist further.
Thank you, Mr. Rees. Mr. Sitema, do you want to add anything?
No comments on this issue. Thank you.
Thank you, Mr. Sitema. Madam Prosecutor, do you want to add anything on the matter of disclosure?
No, Your Honour. Just to reply, just to say that we did a reply to Mr. Rees' email saying that we would give a substantial answer as soon as possible. So we did not leave his email unattended.
Thank you, Madam Prosecutor. Let me now move to the second item on our agenda, which is the status of the SPO's investigations. In its written submissions, the SPO indicated that the review and analysis of recent investigative activities has led to a few additional steps that may run into January 2024. Madam Prosecutor, do you want to add anything to your written submissions on that issue? Madam or Madam Prosecutor, you choose.
Thank you, Your Honour. No, we've provided some detail regarding those few additional steps that we foresee taking in the ex parte submission annex to our submission regarding the status conference, and we would rely on those submissions rather than saying more here in open court.
Thank you, Madam Prosecutor. Now I turn to the defense. Mr. Rees, do you want to make any submissions on this point?
Only this. Given that Your Honour has raised the issue of timetabling, if we are allowed to meaningfully assist with that, then it does require a degree of the prosecution sharing what plans that they have for us to be able to comment on. It's a matter for them whether they do it or not. I do make the point that as of the second status conference, the position was their investigation is effectively over and will be by the time of the third status conference. Now they're not. And with hindsight, perhaps, that assertion was relatively surprising, given the developments that have happened in the interim period between the second and third status conference. All I can say is that the prosecution's investigations are not concluded. And again, for reasons we've set out in relation to disclosure, it does seem to us to be premature to be raising issues as to the timetable for trial, for example, when, as far as we know, the prosecution's investigations are ongoing, and how long it will take for them to conclude, and more importantly, from our point of view, how long it will take us to deal with whatever the results are of those, we're simply in the dark.
Thank you, Mr. Rees. Any further investigations indeed can have an impact on the timetable. Mr. Sitima, please.
Thank you, Your Honour. I can only second Mr. Rees's remarks on this. Much uncertainty in the future, in the near future as well. So, no serious comments can be made on this. Thank you.
Thank you, Mr. Sitima. Madam Prosecutor, do you want to add anything, especially on the timeline of your investigations?
Without getting into further details, I will just stress that we have identified a limited number of additional steps that are necessary. We believe, investigation is dynamic, and of course, this can change, and things have changed. However, we do believe that a relatively short duration of additional time is what is necessary here, and that's all really I can say at this point.
Thank you, Madam Prosecutor. For the next point on the agenda, I would like to turn to the defense first. Before doing that, I wish to underline that I expect that the SPO and counsels for the accused take adequate steps, if necessary, and proactive steps to ensure that the case proceed to trial expeditiously. And I expect the parties to discuss in good faith any issue arising, including access to evidence, in order to find workable solutions and reach satisfactory agreements, and prepare in due time for the transmission of the case file to trial. I also invite the parties to seize me if such solutions or agreement cannot be reasonably searched. Now I wish to hear the defense submissions in light of the information given by the SPO in the course of this status conference on, first, the status of its investigations. Second, any intention to give notice of an alibi on or all the grounds for excluding responsibility and any associated disclosure. Third, any intention to make requests concerning unique investigative opportunities. And fourth, the anticipated date for the filing of a pretrial brief and related material under Rule 95.5, if the defendant decides to do so. And I will start for the defense of Mr. Januzi. Mr. Rees, please.
Yes, Your Honour, in Your Honour's written order requesting submissions, made it clear that Your Honour was to ask whether the defence is, or when it expects to be, in a position to provide more information on the matters Your Honour has just referred to. We have, in our written response, given the uncertainties in relation to not only disclosure, but also, of course, the overall scope of the case, and Your Honour has said that we will deal with the issue as to potential joinder in due course, that we are not in a position today to give Your Honour the assistance sought. When we expect to be, well, perhaps I could put it this way, I would hope that we would be able to by the 4th status conference. That does depend on the disclosure that's made tomorrow and the other matters that have been raised thus far. I can say this, and I have in our written submissions, we cannot see us being in a position to file a pretrial brief by Friday the 1st of March. We do intend to at present, but given that we are still at the very earliest stage of disclosure with the first real tranche of disclosure to come tomorrow, I can't see that being a practical target date for us. And in relation to whether we intend to make requests concerning unique investigative opportunities, again, I can't say at this stage. We echo what Your Honour has said about the parties working together to prepare as expeditiously as possible for the trial, and I hope Your Honour will see from the proactive way that we have been corresponding with the prosecution that that's how we intend to progress matters. But we are not in a position, I'm afraid, to assist Your Honour with the detail of those matters at this stage. Let's hope we are by the 4th status conference.
Thank you, Mr. Rees. Mr. Sitema, please.
Thank you, Your Honour. The same goes for Mr. Bahtijari's defense. Our position is very much depending of the nature of the evidence disclosed tomorrow and the evidence that will be disclosed as a result of the investigative steps that still have been underway, that are still ongoing. There's also the matter of the proposed joinder of the case 11. So only after that, receiving that information, that evidence, the defense of Mr. Bahtijari would be able to enlighten further steps or investigations from the side of the defense. So the same goes for Mr. Bahtijari. Thank you.
Thank you, Mr. Sitema. Madam Prosecutor, do you want to make any submissions on this?
Nothing in reaction to what my colleagues in the defense have said, other than we will continue to engage, of course, as proactively as needed to move things forward, especially in light of the disclosure that will be happening tomorrow.
Thank you, Madam Prosecutor. I invite the parties to continue working proactively ahead of the next status conference so that, as mentioned by the defense, we can be in a position to finalize the procedural calendar during the next status conference. This, of course, means that any matters related to disclosure should be dealt with as much as the parties can before the next status conference. Let me now move to the next item in our agenda, which is the agreement on points of law and fact. I note that the parties have not yet entered into discussions regarding the possibility to submit points of agreement on law and/or facts. I also note that the SPO intends to initiate these discussions with the defense following the present status conference. So I would like to hear the parties, from the parties, whether they can agree on a timeline to reach agreement, if any, on such points. I also wish to recall that there is no obligation from the parties to agree on matters of law and fact before trial. Moreover, any points of law and fact not agreed upon by the agreed deadline shall be left to the determination of the trial panel. Madam Prosecutor, you have the floor on this matter. Microphone, please.
It is my office's intention to engage with my colleagues in the defense in the very short term, but to some degree, I think the timing will be directed by my colleagues in the defense in their review of the evidence in light of the disclosure that is being made, in addition to the materials they already have to consider. But we will be reaching out very shortly.
If the defense is in a position to do so, would you be able to engage in discussions between, I would say, tomorrow and the next status conference?
We do not anticipate any issue with engaging before the next status conference. I'm not aware that we have a date as of yet, but given that we intend to reach out very shortly, certainly we can begin those conversations.
Thank you, Madam Prosecutor. Now I turn to the defense. Mr. Rees, please.
It seems to me that the issue as to whether any facts or points of law can be agreed is a matter that can develop throughout the proceedings. Certainly willing to engage in discussions with prosecution whenever they seek to. And at different stages, we may be willing to make an agreement at a later stage that we're not in an earlier stage because of the way in which, for example, disclosure develops, or the way in which rulings sought from the court affect the position. So we're very willing to engage in communication, inter-parties correspondence, whenever my learned friends across the room wish to contact us, telephone or email. We will always look to narrow the issues for the trial panel. We will do that not only at this stage, but we will continue to do it throughout proceedings. Whether Your Honour wishes to put a formal timetable on that, which necessarily provides for cut-off points, or whether Your Honour is happy to leave it to Prosecution Counsel and Defence Counsel to manage that so that the trial panel is assisted by focusing on the issues that it needs to focus on. It's a matter for Your Honour. We will look to condense matters, whether with the assistance of a timetable from Your Honour or not.
Thank you, Mr. Rees. Mr. Sitema, please.
Thank you, Your Honour. I agree with the submissions made both by the SPO and Mr. Rees. Mr. Bahtijari's defense is also in favor of a very practical handling of the case and is willing to cooperate in any discussion that may lead to that practical handling of the case. So we're willing to do so.
Thank you, Mr. Sitema. Let me now move to the issue of joinder of cases 10 and 11. I note that, as announced by the SPO in its written submissions, the SPO filed a request for joinder of case 10 and 11, namely filing 132. The SPO equally filed such a request in the case 11 file. As a preliminary matter, I note that, pursuant to the rules, the deadline for the defense for Mr. Januzi and for the defense of Mr. Bahtijari to respond to the SPO joinder request falls during judicial recess, which starts on Monday, 18 December. As a result, as I did in previous instances, I intend to modify the briefing schedule to give adequate time to the defense to prepare their respective responses. Before I proceed, I invite the SPO and the defense to make submissions on this topic. Madam Prosecutor, you have the floor. So just on the briefing schedule for the response of the defense.
Your Honor, we certainly have no objection in light of the timings and the way they're working out in conjunction with the upcoming recess with whatever calendar you might propose.
Thank you, Madam Prosecutor. Mr. Rees, please.
Well, obviously, we're very grateful for Your Honour's consideration of our position and the interregnum of the Christmas recess. So we're grateful for Your Honour making it clear at this stage that we will be allowed more time to respond than we would otherwise be allowed under Rule 76. There are issues about disclosure, though, that I wish to raise and really suggest that until those matters are dealt with, the request itself is deficient. And I don't mean that pejoratively, but in the first instance, we would submit that a proper request for joinder should come with the proposed draft joinder indictment. The request asks for the consolidation of the two indictments into one new indictment. What is proposed as the new indictment ought to be part of the request. It ought to be, at the very least, an annex to it. There ought to be, in our respectful submission, a new Rule 86.3 outline, 86.3b outline, which comes with the proposed new joinder indictment. Because although the request submits in very broad terms that the indictments are based on the same charges and facts, there are some quite obvious differences in fact between both the indictment in case number 10 And the indictment, or at least as far as I can ascertain from the public redacted version, because we haven't actually been provided with the indictment for case 11, even though a request has purportedly been made to join our indictment to it. There is an obvious difference that is apparent on the face of the public redacted version of the indictment in case 11. I can go into that if Your Honour wishes me to, but an easy reading of it will make that clear. So the request itself, despite its bold assertions, doesn't seem to me, in short, both the proposed indictment ought to be part of the request, a new 86(3)(b outline should form part of it. It ought to require disclosure of the evidence that was behind the confirmation of the indictment in case 11. That also should be disclosed. Because it's only by disclosure of those matters that one can see whether the bold assertions that are made by the request, that the charges are the same, based on the same facts, is made out. I can't respond to a request in those bold terms without seeing what, in fact, the prosecution is suggesting is to be the proposed joint indictment, what they say the case would be, and a demonstration that it is based on the same facts.
Mr. Rees, I invite you to raise all these arguments in your written responses. I was just asking you for the briefing schedule. So are you happy that I extend the briefing schedule to 1 week after the end of recess?
I would be very happy with that, but I would ask that it comes with a corresponding direction, that before we get to that stage, the prosecution provide us with a draft joinder indictment, a draft Rule 86(3)(b outline, and access to the rule, I'm afraid I can't remember the rule off the top of my head, the rule
86(3)
that required the submission to Your Honour of the evidence upon which the indictment was based for Your Honour to consider confirmation in case 11. Those matters should be made available to us together with the request. Then at that point we'll be able to make a proper response. So I would ask Your Honour to indeed extend the time for us to reply to the request, but in the interim order the prosecution to make disclosure of those matters. It's not disclosure, in fact it's part of their application.
Thank you, Mr. Rees. Mr. Sittema, please.
Thank you, Your Honour. To answer your first question, I'm also happy with the new schedule, considering the coming holiday season. For the rest, I agree with Mr. Rees's remarks on that. So,
thank you, Mr. Sittema. Let me give the floor to the prosecution on Mr. Rees' point about the consolidated indictment and Rule 86(3) outline. You have the floor.
Thank you, Your Honor. I'll just start by saying our request is very closely tied to the requirements set out in Rule 89(1) and entirely proper and complete the way it has been submitted. It's our position as the SPO that based on the materials cited in our request, including the publicly redacted versions of both indictments, it's clear that this is a case where joinder simply makes sense, and that these cases very naturally come together. That said, of course, we foresee that joinder will require the presentation by the SPO of a proposed joint indictment for confirmation, and that would be accompanied by 86(3) outline and materials for disclosure to the defense teams in both cases. And so in order to move things along, and indeed in order to underscore our position and highlight why it is a natural merger in this case to join cases 10 and 11, we would be happy to proceed and provide a proposed joint indictment for confirmation as well as an 86(3) outline.
When would you file the consolidated indictment and consolidated outline?
I pause only because we are up against a recess, which begins at 5 p.m. tomorrow.
You can take your time and consult your colleagues if needed.
Yes, yes, if I could take a moment, Your
We can
Honor.
pause for a minute.
Thank you for that time. We would propose that we be asked to file the proposed materials by the end of our first week back from recess. I don't have the date off the top of my head, but I understand that we are back on January 8th. So towards the end of that week, if we could have that time, that would allow us time to prepare everything.
Thank you, Madam Prosecutor. I will rule on the briefing schedule at the end of this status conference. Before we move to the next topic on the agenda, do you want to add any observation related to your request for joinder, Madam Prosecutor?
I'll just, since I'm given the opportunity, I'll highlight a few things, principles kind of guiding our approach to the request in this case and in case 11. First, the SPO has made the request for joinder at the earliest possible opportunity with a mind towards aligning the cases on the fastest timetable possible in order to ensure that any adjustments that may need to be made can be made at the very earliest stages of the proceedings in both cases, and to then allow the proceedings to progress expeditiously should Your Honor grant the request for joinder.
Thank you, Madam Prosecutor. I turn to the defense. Do you want to make any submissions on the joinder? Preliminary submissions, because you will, of course, have opportunity to reply in writing. Mr. Rees.
Just very briefly, Your Honour, I'm very grateful to the indication that the prosecution agree that they will submit a proposed joinder indictment, a new Rule 86.3b outline to go with their request for joinder. I would ask that Your Honour sets a timetable that I think the end of the week of the 8th of Jan is the 13th of January. So I would ask Your Honour to allow us time after the 13th of January to respond in writing. The rule that I was reaching for was Rule 1021A, the material upon which the indictment in Case 11 was confirmed. I would ask for that also to be provided by the end of the week commencing the 8th of January as part of preparation for the joinder argument. I'm content with the timetable that Your Honour sets, will set after those matters have been attended to. I'm grateful.
Thank you, Mr. Rees. Mr. Sitema, please.
Thank you, Your Honour. No further comments, and I guess the timetable won't be a problem for me.
Thank you, Mr. Sitema. Madam Prosecutor, do you want to add anything?
Yes, just to add that the provision of the 86.3 material that comprises part of our obligation under Rule 1021A, we would be happy to provide at the same time as we provide the proposed joint indictment, as well as the 86.3 outline.
Thank you, Madam Prosecutor. Let us now move to the next item in our agenda. I would like to hear the parties on the transmission of the case file to the trial panel. Pursuant to Rule 72 of the rules regarding expedited proceedings. At the outset, I note that the SPO indicated that it does not oppose the transmission of the case file to the trial panel by 15 March 2024, and that it could be ready for trial shortly thereafter. The defense for Mr. Januzi submitted that it cannot envisage the transmission before May 2024 and trial before July 2024. So I will give the floor to the parties to expand on their written submissions. Madam Prosecutor.
We don't really have anything to add, Your Honor, beyond our submission in our filing. We aim to align the cases in very short order indeed, and don't foresee a problem with the date set forth by Your Honor.
Thank you, Madam Prosecutor. Mr. Rees, please.
The only thing I'll add is that the view expressed in paragraph 16 of our submission is only reinforced by the discussions that we've had today. There clearly is a significant amount of work that the prosecution both are undertaking in terms of their investigations, but also in terms of disclosure matters. We're expecting significant disclosure tomorrow, but there is also a phone that they're in possession of that we weren't aware of previously. And that is a matter that is of obvious significance to the preparation of our defence, how that phone is analysed and the disclosure in relation to it, then analysis of that material. There is the outstanding issue in relation to call data records, which there's an uncertainty as to how that will progress. The actual overall shape of the case, indeed, is not going to be determined until one would think into February at the earliest. Our prediction in paragraph 16 we think still holds good. Obviously, these matters can be addressed again at the next status conference when matters may be more clear. But, and I know that Your Honour will address the potential for the next status conference. I would say this, that the next status conference, it does seem to me, is more likely to be productive if they come after the resolution of some of the outstanding matters that we've dealt with today.
Thank you, Mr. Rees. Well noted. Mr. Sitema, please.
Thank you, Your Honour. The same goes for the defence of Mr. Bahtijari. We have the disclosure of the evidence tomorrow. We have the disclosure of the next investigative steps. We might have the effect of the joinder of the number 11 case. So there's much uncertainty about what this case, how this case will develop. My opinion is that it's getting bigger and bigger by every week or month passing. We don't know what effect the joinder of the case might have if ordered. There's also likely that the defense in the number 11 case has their wishes and their steps being taken. So the time schedule we anticipated on in the earlier stages of this case, I guess they're not very realistic anymore. However, we are in favor of swiftly dealing with the case. But I guess that's not very realistic anymore. Thank you.
Thank you, Mr. Sitema. Let us now move to the next item in our agenda, which pertains to issue raised by the defense for Mr. Januzi regarding IT and facilities available to Mr. Januzi for the preparation of his defense. We will first discuss the issues raised by the Januzi defense in paragraph 17A and 17C of its written submissions, namely the issue of the Zoom subscription and the computer facilities, and we will move into private session to discuss the point raised in paragraph 17B of the defense submissions. Mr. Rees, I'll give you the floor now to discuss point 17A and 17C, please.
Yes, thank you. Well, they both really speak for themselves. The rules provide that detainees in the detention unit will be given access to adequate facilities to assist with the preparation of the defence. There are specific guidelines that make it clear that includes access to computer facilities, computer that they can use. There is a procedure that was created during the course of case 07, in fact, which allowed for each detainee to have access to a computer where they had access to their own quarantined folder that would allow the transmission of electronic material between counsel and detainee. It's called SEDS. It was the acronym that's been given to it. In Mr. Januzi's case, he's completed the paperwork, but hasn't been provided yet with with the computer facilities that would allow him to use that system. And the issue at 17A, again, Your Honour will readily appreciate the difficulties that causes. We have been using the free service that Zoom provides, which allows for an uninterrupted legal consultation of a maximum, I think, of 40 minutes before you are summarily kicked off the system, and then one has to go through the exercise of everybody dialing back in, finding the link, and so on. You know that Your Honour will be familiar with that, as everyone has become around the world. The detention unit did previously have a paid subscription to Zoom, which avoided that issue, and the system worked very well. For some reason, the subscription's been allowed to expire and hasn't been renewed, and we don't know why that is. It's nevertheless, it's an important matter, because when we are booking consultations that last for longer than that, you do lose time having to start the conference all over again. So I do ask, I suggest that the matter should be dealt with. At this stage then, shall I go into paragraph 17B, or does Your Honour want to hear from the registry at this stage?
No, I will first give the floor to the registry, and then we'll move into private session for paragraph 17B. I will give the floor to Mr. Nielsen. I can just, before that, indicate that the issue you've raised in 17A is not specific to the defense, and it's actually something that applies to everyone in this institution recently. Mr. Nielsen.
Thank you, Your Honour. As you pointed out, since about 2 weeks or so, we have had some administrative difficulties with the subscription. So this has prevented not meetings to be held generally, but it has then forced us to have the meetings for 40 minutes, and then you have to redo them. Council raised this issue yesterday with the detention unit with registry staff, and for the DMU. We have found an interim solution, so that shouldn't be a problem going forward. So for counsel and client, this is resolved from now on.
So, Mr. Nielsen, I understand that the problem has been resolved for the defense, but not for anybody else in this institution. Am I correct?
For court hearings, you will have seen that has been resolved, and for you personally, Your Honour, we are working on a solution still. With regard to the second issue, if I may, Mr. Januzi, he has been provided and has a computer in his cell for his personal use. With regard to the SED system that was mentioned, again yesterday morning, the council raised the issue with the staff at the detention unit, that there was a problem, technical problem with the SED. So this was when we heard about it. Following this, some action has been taken by registry staff, and it has been now resolved. So it should from today should start working again. So we just didn't know about it before. Thank you.
Thank you very much, Mr. Nielsen. I see that the problems are or will soon be resolved. Mr. Rees, do you want to add anything?
No, I'm grateful. I hope that Your Honour's problem with Zoom is resolved shortly soon. Can I raise the other matter then, which I understand Your Honour's ruled should be in private session?
Mr. Court Officer, can we move into private session, please?
Your Honor, we are in open session. Thank you.
Thank you, Mr. Court Officer. At this point, I would like to ask the parties and the registry whether they have any other issue they would like to raise, starting with the Prosecutor's Office. Madam Prosecutor.
Nothing further from the prosecution side, Your Honor. Thank you.
Now I turn to the defense. Mr. Rees, please.
No, thank you, Your Honour. Just to warn Mr. Nilsson that I will shortly be en route to get hold of his IT specialist to help me with that hard drive.
Mr. Nielsen is prepared. Mr. Sitema, please.
Thank you, Your Honor. No further issues.
Thank you, Mr. Sitema. Mr. Nielsen?
Nothing further from registry other than that we are prepared.
Thank you, Mr. Nielsen. I will now issue a first oral order. Having heard the parties, I find it appropriate to order the SPO to file its proposed joint indictment and Rule 86.3 outline related to cases 10 and 11. Furthermore, I find it appropriate to vary the time limits prescribed by the rules to respond to the SPO joinder request, which is filing F00132. I hereby order, first, the SPO to file a proposed joint indictment and Rule 86.3 outline, including Rule 86.3 material, on cases 10 and 11 by no later than 12 January 2024 at 16 hours. Second, the defense for Mr. Januzi and the defense for Mr. Bahtijari to respond to the SPO joinder request, which is filing F00132, by no later than 19 January 2024 at 16 hours. And the third, the SPO to reply by no later than 26 January 2024 at 16 hours. This concludes my first oral order. I would also like to inform the parties and the registry that I intend to hold the next status conference the week of 5 February 2024. I recall in this regard that should counsel or the accused wish to participate via video conference, written notice shall be sent via email to the registry 24 hours in advance of the relevant hearing so that arrangement can be made. And such notice should include the written consent of the accused before. You will receive a scheduling order for the next status conference in due course, and I invite the parties to make written submissions if they would like to raise any specific issue during the next status conference. This concludes today's hearing. As usual, I thank the parties and registry for their participation, and I thank the interpreters, stenographer, audiovisual technician, and security personnel for their assistance. The hearing is adjourned.
All rise.